Story noted business leaders say the bill would violate the First Amendment rights of companies. Joining us now to discuss these concerns is Steve Roberts, the president of the West Virginia Chamber of Commerce. Hello, Steve.
Anna, hi. Thanks for having me.
Sure. I want to ask you about the Supreme Court has said that you cannot prohibit companies from talking about the disadvantages of forming a union. Does that First Amendment protection extend to say that you have to be able to allow to make your workers listen?
Yes, it does. The federal courts have dealt with this issue for over 50 years. And to try to make this very fair and understandable to everybody, the National Labor Relations Act creates the National Labor Relations Board. And through the Labor Relations Act and the Labor Relations Board, a carefully crafted set of circumstances is outlined. There are things that employees can do, there are things that unions can do, and there are things that companies can do. And one of the things that is most sacred and most carefully protected is that while unions have the right to talk to employees about what they propose, the employer has the right to talk to its employees about how it sees this matter. And that really goes to the heart of House Bill 4132, and it speaks to why there are such problems with this at the legislature right now.
So I want to ask you, so if employers have the right to talk to their employees, does that mean they have the right to have mandatory meetings that workers cannot opt out of?
They do have the right to have mandatory meetings that workers can't opt out of. And again, because under the National Labor Relations Act, the concern has been that if an employee doesn't attend the meeting or opts out of the meeting, then the employee may be self-identifying herself or himself in terms of how he or she may believe. And so the whole idea has been to say if there's a mandatory meeting, everybody who's required to be there is required to be there, can't opt out, so that nobody gets identified as being a person who doesn't want to hear that or doesn't agree with it or whatever. Now, none of that keeps an employee from saying in the meeting, well, here's what I think, or here's what I agree with, or here's what I don't agree with. I've heard from a human resource specialist today who says, look, we've talked to our employees. They've made it very clear they want the opportunity to hear both sides of the story. And we don't want to see the legislature pass a bill that would prohibit employees or create a circumstance under which employees might not be able to hear both sides of the story.
Well, I want to ask you, the supporters of this bill say this is about workers feeling intimidated. And do you really think there are situations where a worker in a very hot union organizing effort where the company is concerned that an employee would stand up and say, I don't agree with you, my boss,
Well, there have been. There are those kinds of circumstances, and an employee's rights to do that are very much protected under the National Labor Relations Act. So in our country, the answer is yes. In our country, an employee very much has the right to do that. And we think that's a very important right, and we support that right. But we also support the right of the employer to say, and by the way, here's our point of view. Here's how we see this.
So this bill also deals with political meetings. You outlined the First Amendment protections that are through the National Labor Relations Act. How does the political meetings fit into this in terms of the First Amendment?
Well, here's the thing. Nobody's really sure. No state has ever passed a bill like this and allowed it to become law. So there is no other state where anything like this has happened. So it's very hard to look around and say, well, how has this been interpreted elsewhere? The language that is contained in House Bill 4132 says, well, here's how we'll do this, because it's a three-page bill. It's a very, in the scheme of legislative bills, it's a very short bill. What this bill says is that the state labor commissioner will create rules for what you can do and what you can't do, which of course means those rules could change from time to time. And one of the things that employers like the least and perhaps fear the most is a moving set of rules. The rules are one thing one year and another thing the next year, and it makes it very difficult to sort of keep up with the rules. But one of the key problems is that West Virginia would be the only state in the nation to pass this and allow it to become law, if it were to pass and if the governor were to allow it to become law.
New Jersey has some type of law that deals with employee meetings, but
yes,
that doesn't deal with the political aspect of it.
And New Jersey had to take the words labor and union out of its law in order to pass the federal pre-exemption test, the federal preemption test. So the New Jersey situation...
Was it a legal challenge, is that what you're saying?
It was to make it able to pass
Okay.
a legal challenge. New Jersey had to actually take those words out. There is a case pending before the U.S. Supreme Court on this topic right now, and it's scheduled for arguments at the U.S. Supreme Court on March 19th. And it's actually a much more narrow issue. In California, they passed a law that says if a company gets state funds, then it's subject to similar rules that we're talking about in West Virginia. The Ninth Judicial Circuit, which sits in San Francisco and is the most liberal circuit in the country, has said to California, well, you can't do that. You can't pass that law because we already have a very comprehensive federal law in place that protects what workers can do and what companies can do. And the U.S. Supreme Court has agreed to hear that case.
I want to ask you finally, watching the footage from this public hearing that happened last week, companies were very concerned about this bill, some indicating that they would consider leaving West Virginia. Why are companies so very concerned about this bill?
Companies are very, very concerned. I'm here to tell you companies are very concerned. And I think the chief reason is that there are so many unknowns associated with this. There are provisions for fines up to $5,000. There are provisions for a whole new set of lawsuits that we haven't had any of in West Virginia. And companies don't like the idea that they simply would be in the only state in the nation that allows this kind of thing. They view that as being a very onerous kind of situation. So the circumstances has been difficult. We've had very good conversations with our opponents about this. We're having very good conversations with members of the Senate and members of the governor's staff about this. And I think people are beginning to see that while the intent is not anything really the intent is not what people are arguing with. It's the effect of the implementation that becomes such a huge problem. Creates an opportunity for criminal penalties, creates an opportunity for lawsuits, and really stifles the opportunity for employees and employers to talk to each other about issues that probably they both care about.
All right, Steve Roberts is president of the West Virginia Chamber of Commerce. Thank you so much.
Thank you very much.